Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here state of Wisconsin plaintiff. That's an entity. You have to name a person, sir. The date. Well, the date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the State of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the State of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not, or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that they...
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the State of Wisconsin. And with all due respect...
Sir, I believe your Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can a claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record,
And I'm
Your
also,
Honor?
hold on, I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir,
So
based
you're
on law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or fact?
I'm going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without...
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right...
I've already addressed this. Okay? We're not going to have any further argument on this topic. All right? Your Sixth Amendment rights are being honored. no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor. A
Sir,
living...
it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've directed your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to you, sir.
I'm just asking what kind of case it was. Was it federal Supreme Court case?
It's a Seventh Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. But you're citing a court of appeals case.
No, but Court of Appeals case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I'm not going to explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely stating for the record.
Yeah, I heard the door.
Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my accuser.
Your objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses that testify are the accuser. None of the witnesses that testify are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'm saying.
No, I'm confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser. And under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is the issue that needs to be raised.
Your objection is noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of Wisconsin.
Your position is noted, sir.
Is
It's
that
noted
a judicial
for the record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself.
Is that a judicial determination?
All right. I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor? Or is
No.
that a tacit agreement?
I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?